Hello everyone, it's Harry Sherrard here. Welcome to the first video in my Employment Law Foundation course. So the first topic we're going to look at is unfair dismissal. Now, to claim ordinary unfair dismissal, you have to have 2 years service. There are some special categories of unfair dismissal that do not have that 2-year requirement. I'll come back to that in my next video, but for ordinary unfair dismissal, employee has to be there for 2 years. And if there is an issue with the employee, underperformance or conduct, whatever it might be, it is a relatively legally low risk for an employer to bring employment to an end within that 2-year period. Now, what about probation? Employees often think that once they've passed their probation period, they have some different legal status. Actually, they don't. Probation is a management tool. It's not really a legal issue. Notice period would usually increase, generally speaking, from a week to a month. There may be certain benefits that the employer gives once probation is completed, but those are kind of contractual matters between employer and employee. There's actually no change to legal status when someone has finished their probationary period. The big milestone, as I say, is the 2-year service. Now, if somebody has been there for 2 years and the employer does want to bring employment to an end, they need a reason, a fair reason for dismissal, and there's several of those. So, first one is conduct or misconduct, as we would normally think of it. The second one is capability. That subdivides into 2 strands, either incompetence, just simply not able to do the job properly, or ill health. So if for reasons of ill health an employee is not capable of doing the job, that can be a fair reason for dismissal. Redundancy, unfortunately we know all about that one. Illegality doesn't happen all that often, but an example would be if you're employing somebody as a driver and they lose their license, then it would be illegal under the Road Traffic Act for that person to do their job. So that potentially is a fair reason to dismiss. And then we have this other substantial reason. It's not quite as wide as it sounds, but there are certain categories of dismissal that would fall under an other substantial reason. So that's the first hurdle that the employer has to cross to demonstrate one of these reasons applies, or potentially 2 reasons, more than one reason applies to the dismissal. Generally speaking, that's the easier bit, because the second hurdle the employer has to cross is, was that dismissal fair and reasonable in all the circumstances? Now, it's a relatively simple little phrase, but an awful lot hangs off that phrase. So that is why we have an investigation, it's why we have a disciplinary meeting, it's why the employee would be accompanied, it's why we have appeals. You go through all of those processes, you do all of those things so that at the end of the day you can demonstrate that the dismissal was fair and reasonable in all the circumstances. And in the majority of cases where an employer would lose an unfair dismissal case, it would be on this limb. Generally speaking, the reason for the dismissal is obvious, but employers can fall down on procedures by not carrying out the process correctly, and therefore not fair and reasonable in all the circumstances. So that concludes my introductory video on unfair dismissal. As I mentioned at the beginning, there are some categories of unfair dismissal that don't require 2 years service, and I will talk to you about those next time. Thank you.